For those of you who don't know me, my name's Greg Smith. I'm the Legal Practice Director at a group called STE Safety and Legal. We're an incorporated legal practice and safety consultancy. Last year I ran a fairly regular series of video updates looking at various legal issues and legal cases. Unfortunately, the end of last year and early this year has been extremely busy, and I dropped off doing the presentations as regularly as I would have liked. So I grabbed hold of myself and basically applied a bit of operating discipline, and hopefully I'll be in a position to post these presentations more regularly. At the end of last year, we were working on a series of cases looking at contractor safety management, and there's been a very recent decision, the Waco Kwikform decision, which is ideally on point, looking at the issue of contractor safety management. So I thought I might pick up from where we ended at the end of last year with another case looking at contractor safety management. For those of you who regularly tuned in and looked at these videos last year, you will understand that this is a conversation today of a general nature only. It is not legal advice. It shouldn't be taken as legal advice for your business. But clearly, if there's any issues that fall out of this presentation that cause you concern, I would strongly encourage you to get legal advice to understand exactly how it does impact on your business. The Waco decision was relatively straightforward from a factual perspective. There was an employee called Mr. Perijo, I assume that's the correct pronunciation. Mr. Perijo was employed by a group called BTSS. BTSS was in the business of supplying labour to erect and dismantle scaffolding, so they provided scaffolders. Waco Kwikform was in the business of supplying the physical scaffold, and they subcontracted BTSS to supply the labour for the job. Axis Construction was the appointed principal contractor under New South Wales legislation at the time, and so they were the principal contractor for the overall construction project where this scaffolding work was being undertaken. Now, in the context of this case, the 5th of May 2006 is the really important date. On that date, a BTSS employee was injured in a fall at work. So Waco had engaged them, they're doing the scaffolding work, and there's a fall and an injury. And at that point, Waco decided, well, we don't want BTSS doing work for us anymore, they're too unsafe. There had been a previous fatality with BTSS in January, and that obviously played into Waco's decision making. And so the original plan was they were going to dismiss BTSS and they wouldn't be involved in the job at all. But then, following some negotiations with the union, Waco agreed to allow 9 remaining BTSS scaffolders to finish the job. It'd be interesting to peek behind the curtain of those negotiations. But in any event, regardless of how we arrived at the position, BTSS was still supplying labourers as at the 16th of May 2006, and that's when Mr. Perijo fell and was seriously injured. It was an 8-metre fall. Now, in this context, Waco was not the principal contractor. They weren't the direct employer. They were a contractor themselves, having been engaged by Axis for the purpose of this construction job, and they'd engaged BTSS as a subcontractor. And one of the key questions that arose was the scope of Waco's duties and their responsibilities, both for the system of work that was in place at the time of the accident, and then their obligations to BTSS's workers. Now, bear in mind, this is not an occupational safety and health prosecution. Rather, this is a claim for damages. So this is people suing each other for money because somebody was injured. And I'm not a personal injuries lawyer, and I don't pretend to be. But what we see coming out of this case is some very interesting discussion and a range of principles that I think are entirely consistent with a lot of historical cases looking at the principal-contractor relationship when it does come to occupational safety and health, and in particular, how the actions of a principal can result in them assuming responsibility for their contractors in circumstances where they might not ordinarily have to. There are two key findings. The first finding was, it's really one finding, but divided into two. The first key finding was that before the 5th of May, Waco had acted reasonably in engaging BTS as an independent contractor who were apparently competent to control their own systems of work, and in those circumstances Waco had a responsibility for a supervisory function at a high level, but under no continuing duty to prescribe or enforce a safe system of work for the dismantling of the scaffold. And I think this is an important distinction to understand in the principal-contractor relationships, insofar as the relationship can certainly be developed so that a principal, whilst having a supervisory function, isn't necessarily responsible for the prescription and enforcement of a safe system of work. And I want to explore that in a little bit more detail in a moment. But the flip side of this finding was the position that the court took after the 5th of May. So the 5th of May was that critical date when there was an incident and Waco decided they didn't want BTSS working for them anymore. And the court said that after the 5th of May, Waco assumed control of the system of work and they took substantial responsibility for direct supervision of the workers. Fundamentally, I think the court was saying after the 5th of May, Waco took responsibility for these workers. It was up to them to supervise the work, to ensure that the system of work was safe, and to ensure that the BTSS workers in fact followed that safe system of work. And there were two crucial factual findings that seem to have led to this position. The first one was that Waco prepared a revised safe work method statement. So it was actually a Waco document that was prepared and provided to the BTSS employees, and so this is the system of work that you shall follow. And then they took a much greater responsibility, Waco took a much greater responsibility for day-to-day supervision of the dismantling of the scaffold. In effect, they had a supervisor there watching the job. And the court's finding was that Waco assumed control of its subcontractor system of work because they were no longer satisfied about BTS's competence. Now, to me, this finding is entirely consistent with case law, both in the personal injuries area and also in the occupational safety and health prosecution areas. And we've seen a number of cases, including cases like the Badia chicken case, the FMG Cyclone George prosecution cases, Tobias and Riley, a WA Supreme Court decision that was due to go to the High Court and didn't make it there, all of which have said fundamentally that a principal is not usually responsible for the way that an expert contractor performs their job. And fundamentally that if I engage an expert contractor to do their work, then in the absence of something that puts me on notice that they can't do that job, I'm entitled to a large degree to assume that they're doing that job competently. This is a quote from another case that was cited in the Waco decision. It was the latest contractor case, but fundamentally once the activity's been organised and its operations are in the hands of a contractor, liability for any negligence in the way that that contractor performs their job sits with the contractor, not with the principal. But I think an important part in that passage is once the activity has been organised. And I think one of the key fundamentals to good contractor safety management is the amount of time and effort we put up front in organising and defining responsibilities and understanding what the work to be performed looks like and how it's going to be controlled before we actually commence the work. Unfortunately, as a matter of practice, more often than not, we get onto site, we get the work going, and we kind of muddle our way through those responsibilities as the project moves and shifts. And it's that lack of clarity, I think, between the parties that fundamentally creates most of the legal risk and, quite frankly, the safety risk, which I'll talk about in a moment, in these relationships. So while I think it's pretty safe to say that a principal is not generally responsible for the way that an expert contractor performs their work, once a principal takes responsibility for the work of that contractor or imposes requirements on that contractor, then that's what we get held accountable for. In the Waco case, the court said that the primary responsibility for adopting and following a safe system of work was assumed by Waco. And once they assumed that responsibility, once they took that on, they had taken the primary responsibility for the safe system of work out of the contractor's hands. And that's something that we see a lot. You have an expert contractor employed for their expertise, performing work in a project environment. They have a couple of incidents, they have a couple of lost time injuries, and then all of a sudden, the principal is suddenly sending supervisors down there, telling them how to do the job, rewriting their safe work method statements, rewriting their JHAs, rewriting their procedures. And as soon as we start to cross that threshold, we suddenly increase our legal liability significantly. And again, I'll touch on it in a moment, I think we fundamentally increase safety risk as well. I think one of the key issues that organisations need to understand coming out of a case like Waco, and again, I think it's consistent with the law, I don't think there's anything that interesting or different about the case, but I think we need to understand that there is a significant difference between holding a contractor accountable for their system of work and imposing our systems and telling them how to do their job. Because again, once we cross into that realm of imposing our systems on contractors, telling them how to do their job, fundamentally we become accountable for that system of work. Just a couple of other things I think to bear in mind if you're looking for the lessons in this case. Because it was a personal injury decision, if you're applying these lessons, and I think they do apply, but if you're applying them in an occupational safety and health context, you need to be aware of your specific regulatory requirements. And around most of the jurisdictions in Australia, harmonised or not, particularly in construction projects, there are mandatory statutory requirements that are imposed on different parties, be it principal contractors, clients, managing contractors, however described. So whatever we might understand by the principles in the Waco case, if there is a mandatory regulatory requirement to prepare a form, give information, prepare a report, that still exists and that can't be changed by the contractual relationships between the parties. I think overwhelmingly the management of contractor safety or managing contractors as a safety issue requires clarity of roles and responsibilities between the principals and the contractors. If we don't have absolute clarity about whose processes apply and who's responsible for doing what, the whole structure becomes very muddy, and it becomes far more likely that we are increasing both safety and legal risk. I've touched on it before. I think there's a significant distinction between managing a contractor and managing their safety. And unfortunately, in my experience, the safety profession, I'll put my hand up as one of them, historically has not been very good at managing contractors. We're far more comfortable as a profession to go in and start talking about how to do the job safely, rather than walking in with the contractor's contract and the contractor's health and safety management plan and saying to them, this is the plan that you said would manage the risks in the business, and it's not. And I want to know, as the principal, whether the plan's not working because the plan's no good, and if the plan's no good, I want you to go away and write me another one. Or is the plan not working because nobody's following it? And if nobody's following it, I want you to go and enforce it, and I'm going to hold you as the contractor to account against that. I'm not going to tell you how to do your job safely. I'm going to hold you to account to the processes that you said would manage the risks in this business. And I think that's an important distinction we need to understand, and I think there's a lot of upskilling in the industry that's needed before we get that right. Because once we go in, if we move to that next bullet point, once we go in and start managing safety, if we impose the safety requirements, we own it. One of the video cases that is available on the blog is, excuse me, the KCGM and Ausdrill case. And if you look at that decision, you'll see very clearly how, where a principal imposes the requirements on a contractor, in that case it had to do with traffic management. Once you impose those requirements, you own it. And I think the last thing to take away from this, again, is once we start interfering as a principal in the way that the contractor actually does their job, I think we start to create significant risk in the business. Now, the two simple ones, increased legal risk for all the reasons we've described in this case. I think we also start to run the risk of potentially acting in breach of the contract, which creates a whole different raft of problems which we won't talk about. But I also think there's a genuine concern that we create increased safety risk. Quite often, if we come in and impose new requirements on the contractors, it creates confusion. It creates confusion amongst their workers about what are the processes I'm meant to be following. And at its most basic, who's to say that we are actually any better at managing the risk than the contractor? Because that's their business. So I think we, as principals, need to be extraordinarily cautious about coming in and telling contractors how to do their job. Finally, I think we can wrap up this contractor safety management discussion by saying, fundamentally, look, do we understand who is responsible for what, and do we manage accordingly? And by that, if we say the contractor provides a health and safety management plan, and they've told us how they're going to manage the risks, do we then manage them against what they've said as opposed to telling them how to do the job? If, on the other hand, we tell the contractor how we want the job done because we think we know better, which is fine, that's legitimate, then we have to manage it like we own it. We have to have the right levels of supervision, we have to have the right assurance, we have to have the right confirmation, we have to really manage the safe system of work as opposed to managing the contractor against their safe system of work, which is different. And if it's not too much of a plug, I'm sorry this is not a marketing exercise, but a lot of these concepts have been explored in quite a bit of detail by some really clever safety and psychology personnel in the book Contractor Safety Management that we put out at the end of last year. So if you're interested in exploring this a bit further, that's another terrific resource I'd encourage you to go and have a look at. As always, thanks very much for your time and attention today. All the links are here, so if you want to get a copy of the case, if you want to follow the blog, get updates, get alerts, find out more about us, all the details are there. But again, Thanks very much for your time. I hope this was useful, and I look forward to putting out more video presentations on a regular basis. Thanks a lot.